All right. So guys, let's get started because we have a big presentation. I don't wanna, I know we'll probably got people walking in here, but trying to get everybody to try to be like 2024, get here on time and stop being so late to the office. So if you guys can't hear me on the Zoom for whatever reason, let me know, but you guys should. All right, guys, so we have a really special guest today. Vanessa Marie Milham. I pronounced that. I was worried about the Milham part. She's an attorney and she's a practicing law attorney with Alvarez Law Group, right? And so she does a lot with real estate. She does a lot of things when it comes to real estate. She's involved in a lot of real estate organizations. Especially when it comes to the educational aspect of things. So we wanted her to come on board and kind of teach us about, foreign buyers, how to deal with like what's going on with these new laws where like can foreign buyers buy here? Can or where's the exceptions? And basically how can we have knowledge so when we do speak to a client from Colombia or Venezuela or Mexico or wherever it is that we have a potential opportunity, what are the laws that we kind of need to know? What are the things we need to be aware of when it comes to the laws for them to purchase here? And also tax implications as well, okay? And how all that works. So I wanted you guys to kind of have some knowledge. So please, this is going to be a really good session. Take a lot of notes. I want to take 5 minutes real quick to talk about the NAR stuff. I promise you guys we're going to talk a lot more about this over the next few weeks. So basically what happened was NAR, they had a proposed settlement, which is not approved, but everything, it's still pending approval, but it looks like it should be approved. And there are going to be some changes coming into our industry. There are going to be some changes. My biggest recommendation right now is just, just wait out to see how it's all going to play out. Major changes that are going to be happening is like the MLS will no longer offer compensation on the MLS. Okay. So when people hear that, right away they assume a lot of other things like there's no more MLS offer a compensation on the MLS. So is it possible that now buyers are going to have to pay an agent's compensation? Possibly. Okay. That compensation field, from what I'm reading, okay, is going to be replaced with a seller concession field. And then basically through a buyer brokerage agreement, which by the way, that's another big change. We'll have a buyer brokerage agreement. So one thing we're going to be doing a lot of training on in the coming weeks is buyer consultations, buyer brokerage agreements as well. Because let's be real, a lot of us realtors don't use those. We probably have agents here that have sold a lot of real estate, have never even looked at a buyer brokerage agreement or know what that is. So that's something now that is going to be absolutely necessary for you to even start working with a buyer. So we're going to do a lot of education, a lot of training on like how that document works, how to fill it out, and just be prepared. That's all we're saying. We just want to be prepared because if these changes do take place, they would take place in July. Okay. So that's basically, so one of the things I'll be honest with you guys, all it is through our time here, talking about this before we got on the Zoom, is there's always been changes. There's always been changes. It's not the first thing we deal with that's a change in our industry. So all it means is you're gonna have to be better. You're gonna have to be better. You're gonna have to articulate your value proposition better. You're gonna have to get buyers. And by the way, I know we're used to one thing in Florida, but there's other states where buyers do pay commissions. There's other parts of the world where buyers do pay commissions. So there's, don't always think this is the way we've always done it. We can't do it any other way. Absolutely not. We could always adjust and we'll get better at it. And over the next couple of weeks, we'll definitely start preparing just in case, all this stuff comes to fruition, all this stuff happens. So, if you have any questions, reach out to me and talk to me. We also have Vanessa here. Again, she's very involved in education. So after we talk about all this stuff, I'm sure she will give us a few minutes of her time to give us any insight, answer any questions regarding this stuff, or maybe the NAR settlement. If you have time, I would really, I'm sure everybody would really appreciate that. So, so she's here. If you're on the Zoom, I'm sharing the slides. But if you have any questions, I'll be monitoring the chat so that you can see it. If I have any questions, I'll tell you something in the chat. All right. So without further ado, you got the mic. Take it over. Okay.
Yeah. So good afternoon, as I met, some of you, my name is Vanessa, and I'm an attorney with the Alvarez Law Group, and I specialize in real estate. I also do trademarks, but the primary, amount of my time is spent with real estate, so I do a lot of this educational chats, just because it's very important to me that you guys have all the information you need to be able to best serve your clients, to make sure that your transactions are going through without any issues, and your contracts are airtight, they're done correctly, and you're serving your client to the best of your abilities, which we hope results in referrals, right? That's the whole point. So today I'm gonna be talking to you in two-part because there are now, with the new Florida law, there's things that affect foreign buyers, which we didn't see before, and then the second part is foreign sellers and what happens when we're closing. So the first section, the Florida statute, now it's a Florida statute that it's been signed into law, it's 692, and I put the numbers up there. And Victor has a presentation for you guys after, so you can go ahead and look at it. It's actually a lot simpler of a law than I thought it would be when they first started talking about it. So if you read it on your own, and it's pretty basic, you can read it. It's not gonna be something super complicated, and it's good to have the numbers because in there, a lot of the pieces that are in the presentation are also in there, which is the list of the countries that are considered part of countries of concern. And it has the details as far as what type of properties fall under this law, because it's not every property, and we're gonna go over that. And so it has little bits and pieces that are actually good. If you ever can't remember some of this stuff, you can go back and look at it, and it's generally well worded, not perfect, obviously. So Florida statute 692 came into effect July 1st of last year, so that we all know we started scrambling because the FAR bar changed to version 6X. And what does the law do? It restricts the acquisition, and we put acquisition, not purchase, because it's not just by purchase that you get restricted, of Florida real estate by foreign principals from these foreign countries of concern. And as you see, it says already owned or after July 1st, acquired, purchased, etc. So what's important to realize, and we're going to talk about it a little bit more or remember, is foreign principals does not equal every foreign individual. It's foreign principals from foreign countries of concern. And these are the foreign countries of interest. I'm not gonna read them for you because obviously the list is there, like I said, and the law has it actually listed out like this. So if you ever have a question, you honestly could just Google the SB 264. It will come out immediately. You'll be able to get this list.
I have a question.
Yes.
So you, on the previous slide, so this also applies to properties they already own?
Yes, there are parts of the law that talk about properties already owned and properties acquired after July 1st of last year. And we're gonna definitely touch on all of that. So foreign principals, there are a couple of descriptions on there. Obviously, a government from another country, from one of the countries of concern, not any foreign country. Political party or political party member, a partnership. I'm gonna say an organization meant for business, because obviously there's a bunch of descriptions there of types of businesses, but it's an organization for business purposes that is either organized under the laws of one of these countries of concern, or it has its place of business there. So it can be organized under the laws, let's say, of the US, but it is situated in one of these countries, it is gonna fall under this. And then the person, as far as people go, individuals, it is if they're domiciled in a foreign country and of concern specifically, and they are not a citizen or lawful permanent resident. And I've had a lot of questions, and I'm actually going to go into detail about this when somebody asks me, well, what if they have a visa, this type of visa or that type of visa? If they're trying to be excluded entirely as a foreign principal under this law, the only two exclusions are citizen or lawful permanent resident. There is an exception that I'm going to talk about that does mention types of visas, but it is only if you're going to use that exception specifically. If you are if your client is just trying to purchase a property and they want to know if they fall under this, the only way out is being a citizen or a lawful permanent resident. And that's when they're domiciled in foreign country of concern. So what I've had issues come up with is, for example, Canada is not listed on this list of countries. But a Canadian citizen living in Venezuela is neither a citizen nor lawful permanent resident and happens to be domiciled in a country of concern. So that will cause an issue during purchasing. So you have to be cognizant of both of those things, because they could possibly not be somebody that falls under this because they're a citizen of or from a country that is not a country of concern. But they are there then domiciled in these countries, and then they will be excluded from certain purchases per this law.
What does domicile mean? I don't know what it means. Okay,
Living there.
Cool.
But living there, like, you're not just vacationing, you know,
We live there.
summer, that is your primary residence location.
Okay, cool. Sorry,
Um,
English is not my first language.
I
Isn't
do
it?
it in Spanish too. Domiciliado.
Yeah.
So, in addition to all of these, so a person or entity that falls under A through D that has a controlling interest in a US partnership, LLC, corporation, that is made for the purpose of buying real estate is also out. Yes,
How long, sorry, to interrupt. How long does that have to be considered for it not to be a domicile? Like, how long do you have to live in a country for it not to be considered a domicile? Like, let's say,
so right now there's not timelines, right? That's what I'm saying. This law was written in an easy way to read, but it's obviously not perfect because there's not timelines. Domicile is not determined by this law. It is determined more likely than not by the immigration laws. So whatever their requirements for being considered domiciled somewhere is what's gonna apply.
so it's not tax code, like,
It's not what?
not like the tax code, like people that live in New York and they spend most of their time here, they file the taxes Florida instead of New York. because-
So not where you're filing, but there are things that you do, which is what allows you to do those kind of filings.
Okay.
Things, actions that you're taking that are what determine domicile, right? So on a very basic level, this is obviously not one of them, but on a basic level, let's say I get my mail in this location. Right, like I reside there the majority of the time, I pay bills there, I like. Put it out into the world that that is my location. There are actions that you take that affect this or decide this matter. So, one more thing that is very important to take into account, the restrictions for foreign principals from China are a lot higher. There is only 2 exceptions where they are gonna be able to purchase. So from that prior list of countries of concern and foreign principals, the other countries, if they're a foreign principal from there, based on this list, they are going to be able to still purchase property. Except the ones that are gonna be listed here that I'm gonna explain, they'll still be able to purchase property. Except for the foreign principals from China, they can only purchase under the 2 exceptions I'm gonna list. That's it, so if you have a buyer that is from China, is a domiciled in China or is a citizen of the Republic of China. You are going to have to keep in mind that they can only do so under those 2 exceptions. Very likely only under 1 exception, because the other one is for political reasons, so probably just 1 exception. So that's gonna be very limited, you have to take that into consideration, whether they're gonna be able to purchase or not. So these are the main restrictions. It's number 1 is they cannot purchase properties within 10 miles of military installations or critical infrastructures. So they can still purchase, like I said, just cannot be within that distance. And the other one is they cannot at all, period, point blank, purchase agricultural land. So that is now a like entire restriction. Okay, so that's what's restricted.
I had heard that it was a 10-mile radius. It's not a radius, it's just 10 miles.
It's just 10 miles.
Okay,
The-
it makes a difference.
the-
Big difference.
It actually, I'm gonna tell you, it actually doesn't, this is why.
No?
There's
Okay.
no official map. And there will never be an official map, and I actually have that up later on, but there's no official map. For obvious reasons, this was made for security purposes. Florida is not going to put out for potential terrorists
Yeah.
a map that delineates the specific locations they don't want these specific people buying near. So, which would essentially become a target list. So, the 10-mile thing, take it with a grain of salt and be extra cautious because they have not, for example, in Doral, there's Southbound, right? There is no specific map showing exactly at what point Southcom ends and where you can start counting those 10 miles from.
Yeah, so how, so,
You don't, you just gotta be extra cautious, because realistically, that can become a problem, and because they are not going to put that out.
So what is a critical infrastructure facility exactly?
There's actually a list.
Okay, perfect.
I'm gonna get there.
Awesome, awesome.
So this is the descriptions of the military installation. Again, like I said, I'm not gonna read this to you because this list for military installation and this list for critical infrastructure is actually in the law, listed like that. So you don't have to guess, you don't have to guess in between parentheses because they list what kind of infrastructure, they obviously don't list the specific locations that fall under this. But you don't have to guess as far as what could be in that list, and it's listed on the law, so. It will tell you a base, a camp, a post, a station, etc. And like I said, there is no map, there will never be a map. But the Florida Department of Commerce, which is responsible for the registrations, and I'm gonna touch on this a little bit more. Of the properties that have been owned before July 1st, when it came into effect. That they have to register there, they have a search engine. Again, err on the side of caution because the search engine is not perfect, it was created very haphazardly, very like last minute, so. I've already like played with it and doesn't always pull up. That an address needs to be registered, meaning it doesn't always pull up that an address falls within those 10 miles. So
oh, but there is something that we can go and just put an address and tell us yes or no?
Yeah, but look, it says
Right,
airports, for
okay,
example,
but-
like, there's an airport every 7-8 miles,
yes,
at least south down here, so it's like, alright, so we're. You don't have to go to Oompa Loompa, Florida, or, no, there's a city, sounds similar. Like,
yeah, unfortunately, yes, and 10 miles is actually a lot, more space than we generally think. I mean, being in Miami and we are, or South Florida, we drive a lot, so 10 miles to us is, you know, we don't really take it as much into consideration, but it does take up a lot more space than we think, and that's why I say, like, yes, you can look up the addresses, but take it with a grain of salt and still maybe do your own research or have them talk to an attorney if there is a property that they are dead set on and you know that they fall into this this law, they fall under this, the restrictions of this law. And the thing is, like, as I mentioned in the form principles before, they are not gonna be able to create a corporation, LLC, a partnership or whatever that's domiciled in the United States or Florida per se, that's gonna be able to exclude them, because if they have the majority ownership of it, or any ownership that's more than a minority, they will still fall under this, even if they're purchasing it under the company's name, so,
whose due diligence is this, will be an attorney or a title company?
no.
The buyer?
Unless they hire an attorney.
Right.
But it is the buyer. That is why, at every step of the way, I will say, if there is any doubt, they do need to hire an attorney. 100% to give them an opinion on this. On the risk level, a risk assessment, because essentially, it is the buyer, and it comes up in a couple of slides. The buyer is going to be signing that disclosure, that's now part of the 6X, and then they're gonna be signing an affidavit at closing. So it is a lot on the buyer. There obviously are repercussions for everybody else involved if they knowingly still help the transaction occur, but it is mostly on the buyer.
Are there different rules if the property is given like a probate or?
Yes, it's under here. We will get there. Okay, so as far as important requirements go, number one, like I said, the disclosure that we all know and see, that's on the 6X. If for some reason, I don't know, hell has probes over and you guys do not have access to 6X at some point when you're doing something, there is actually an addendum that has also been provided, that has literally this exact same little square on just a separate sheet, if you ever need to put it on there, onto some other version, just so you guys know. And then the other one that I was mentioning was there's an affidavit at closing that the buyer has to sign. The law just says at some, like, prior to the transaction, which really honestly just means on or before the closing. It happens at closing because that's when the buyer generally signs everything, so Just so you have an idea, if you guys ever wanted to get a copy of it, you can get a copy as well, just for your records to CYA. Now there is an official one from FREC, but essentially the affidavit, the way it looks is it just has like a little sign, a little line for them to initial. It's either they do fall under this regulation or they do not fall under this regulation. And it has just some of the Florida statute like pieces in there that tells them. And then there's like 3 or 4 pages after that has a broken down information for the buyer so that they, out of an abundance of caution, know what they're signing and know that they do not fall under this. So another important requirement is for property owners that owned prior to July 1st, which is something somebody asked me about prior to July 1st. There are 2 departments, excuse me, in Florida that are handling the registration. So Agriculture and Consumer Services is handling for agricultural lands, of course. And their deadline was January 1st, and then there's going to be fines and potentially liens imposed of $1,000 per day after the deadline, which we already passed. The military installations and critical infrastructure, so like the properties within 10 miles, of course, is the Florida Department of Commerce, and their deadline was December 31st, but if I'm not wrong, they actually were giving like the final day to start putting fines was January 31st of this year. And I have those websites on there. I can provide those to you if you ever have any questions, but that website where it says Florida Commerce, that's the one where I mentioned that they have that search engine. It is like the first thing you find on the page when you go there. And same thing, they have $1,000 per day, they'll put liens, and eventually we may see it escalate to the point of civil forfeiture. So they're gonna essentially foreclose on the property. We haven't gotten there, and I actually have not yet seen liens, but eventually we may start seeing that. Now, for properties acquired after July 1st, which is what you were asking me. These we're talking about not by purchase, because obviously they are now restricted so that they cannot buy these properties. But if a person, a foreign principal from one of these countries acquires via a device, which is a will, somebody passes away, descent, foreclosure. And foreclosure, of course, if they were the mortgage holder for a property, they gave, let's say, seller financing or something of that matter. And the affected property falls under these restrictions, because they are a foreign principal from one of these countries, and the property happens to be within 10 miles of one of those or agricultural lands. They have 3 years to divest the title. So that means they have to sell it, gift it to somebody, transfer it, whatever they want to do, but in 3 years, it can no longer be under their name. Just a decent amount of time, honestly. In 3 years, you have a good amount of time to figure something out, what you're gonna do your plan. So these are the exceptions. As I mentioned, I'm gonna actually start with the bottom one, the diplomatic one. You're almost never gonna see that. That's very rare, obviously. But diplomatic purposes is one of the exceptions for any of the foreign principals that fall under this restriction. And including China, the residents or principals from China. The one residence exception, that's the one that I was mentioning, that it'll probably be the only one that you actually use for the principals from China. And that is that they are allowed to purchase one property for their primary residence. And the requirements is it has to be a natural person, so cannot be a company, has to be the individual. They can purchase one property, no more than 2 acres. It cannot be less than 5 miles from a military installation. Doesn't matter about the critical infrastructures, if the military installations no less than 5 miles. The person has to have a current US visa, and it can be a tourism one. It has to be one that authorizes them otherwise. Or documentation confirming asylum, because we all know some of these countries do have a lot of issues that are causing asylum. And they have to be otherwise authorized to be legally present in Florida, because that's going to be their primary residence, so they have to be allowed to exist in Florida. They are going to have title in their name, so in the name of the person who is getting the visa or documents that prove that they fall under this. And the final one is they're gonna have to register, so they have 30 days from the closing to register. That's pretty much it. That's the only exception that China, the principals from China are gonna be able to use. And this exception is allowed to any of the foreign principals. But please remember that if they already have one property, they're not gonna be able to buy this. They can only purchase one property under this exception.
And they have to, and it has to be for primary residence.
Yes,
Okay,
not an exception for investment purposes, which I know unfortunately a lot of people want. So, as I mentioned, there's obviously violations. They are criminal, not even civil. They are criminal violations. For foreign principals from China, obviously they're a lot higher because the restriction is higher for them. For other foreign principals, second degree misdemeanor. For anybody that is knowingly sells a property, so that means that can include title attorneys, agents, seller, obviously. This is what the violations will be. And knowingly means, just so everybody's super clear, knowingly. Knowingly does not mean I have a hunch, there was a rumor. It means you have actual knowledge, meaning the buyer has actually told you they fall under this and cannot buy it, or the buyer's agent has told you, or there has been documentation. Not, I suspect because I spoke to them and they had an accent kind of thing. That is not it. Another big thing is, as agents or title attorney, or even the seller, you are not responsible for filtering the buyers. That is why that disclosure is actually on the contract. Because it is obviously a violation to ask where these people are from. So we are not doing that. We're just making sure that they're signing either the 6X version of the contract or the addendum. It is disclosed there. It is a responsibility of the buyers and the sellers to sign, to read, the terms of the contract. If they are unsure of the terms of the contract, they can hire an attorney to explain all those terms for them. It is part of the contract language that they are entitled to get an attorney to explain this to them.
but as a seller or listing agent, it's not our job to.
No.
do that. Okay.
Not even a buyer's agent is responsible for this. It's not your responsibility to do so.
So then
The only person really subject to these are the buyer and the seller, because they are the ones that are party to this contract. That's why it was put on the contract.
but is there, so do I need to worry about our sellers being liable for something to, if they sell a property to,
If they are aware, they have
they're aware.
actual knowledge.
Yeah, okay.
Kind of thing. So if they are not aware.
Yeah.
And the buyer obviously hides this information and fraudulently goes through with this transaction, the seller is then, no longer responsible. But again, like I said, it's something that, for example, I always do when I'm representing sellers since July 1st is I will always get a copy for my sellers of the new affidavit, I still go by the state bill name, the 264, because most people, it's a mouthful to say the actual Florida statute number. But I will always ask for a copy of that affidavit, just to make sure it got signed at closing and it's notarized, and then, otherwise we don't have any actual knowledge, so it's not our responsibility. We are not responsible for enforcing it, okay? And, something that should be abundantly obvious, but just in case, if a land is sold in violation of the law, it will be subject to civil forfeiture. They're gonna take it away, the state's gonna take it away. Just depends which one of the departments is responsible, and they'll be the ones doing this. So that's it for the foreign buyers section. So I'm gonna take a 2-minute break if you guys wanna ask any questions, there was anything you weren't unsure, if there's anything on Zoom they wanna ask.
Yeah, any questions, guys, about anything of that? My main thing is I get calls all the time, like, hey, like, I have a client coming, so my question would be more on the foreign principal, I guess. It sounds to me, based on what you said, they have to be government related, is that kind of what I'm seeing, pretty much?
To be able to be excluded?
No, like, they're considered a foreign, what was the
No,
term?
foreign principal is just like a term, but it has that definition that, I don't know if you want me to go back to the slide so we can take a look at it,
Yeah.
but these are the definitions, these are the different categories. So a government from one of these foreign countries of concern is considered foreign principal. A political party or political party member from one of these countries of concern, also foreign principal. a partnership, association, so any kind of
So
business.
these are the people who fall under this situation.
Fall under this
this law, like-
category.
Right,
Well, no, let's separate them,
Okay.
because you can have people, let's say, for example, like I said, Canada. That fall under this definition, but because Canada is not in on the countries of concern list, they don't fall under this law. Unless they are domiciled in one of these foreign countries.
okay, so let me rephrase the question a better way. I have somebody who reaches out to me, hey, I'm gonna put you in connection with a client in, let's just say whatever, one of the countries, Venezuela, okay? So as an agent, what do you recommend, what kind of questions we ask to that person?
None,
To,
not a single one.
Don't ask them.
If they are from Venezuela and they are unsure if they fall under this, they need to talk to an attorney. Period. As agents, you guys are doing yourselves a disservice
Okay,
and
by even
causing a
asking.
lot of liability by even asking. Just by them being from this country of concern, the best thing they can do is to talk to an attorney. They can talk to an immigration attorney, they can talk to a real estate attorney. But you guys should never be advising them on the possibility. Just the only thing that should be coming out of your mouth in that second, just to cover yourselves, is it is one of the countries of concern. The best thing you can do is talk to an attorney. I cannot advise you because you guys are not set up for that, and you can cause a lot of liability issues
good,
for saying something like that, right? So the best thing is CYA. I can't make that determination for you, but it is a country of concern, so you should talk to an attorney about it.
okay,
Honestly, the only thing other than that, the only exception is, are you a US citizen or legal permanent resident? That's it. If you even wanna go that far. But again, like, I know that a lot of people are uncomfortable talking about that with certain people, so if you are not, and if you don't wanna ask that kind of question, have them talk to an attorney.
right.
It's the most simple thing, and I'm gonna say the same.
So I would say our conversation would probably be like any other buyer, but just add that part to it. Well, I mean, if they're interested in buying here, I'm not gonna just tell a client, oh, well, listen, I can't even speak to you, like, I have to still ask them, what are you looking for, what's the.
Absolutely.
Yeah, of course, talk to them like a regular buyer, but then I need to add,
Absolutely.
hey, because you're from a country of concern, let me recommend you some attorney that you can speak to, or speak to an
Right,
attorney.
and I can give you, there's, from the affidavit, like I was mentioning, the affidavit that signed at closing. The second and third page are like a description of the law. And so that's something that you can even send over if you're sending something of information to the buyer. And I definitely am not telling you like, you cannot talk to them, still get all the information, obviously, because this law is not precluding it, with the exception, of course, of the foreign principals from China. It is not entirely precluding these individuals from purchasing. It is precluding them from purchasing certain properties. And that's something that I keep telling like agents, very important to keep in mind. You just gotta get more creative, but it's not entirely precluding them. They can still buy. They can still even form a company and buy into the company. They just can't buy because they form a company, these excluded properties. They just have to take into account these excluded properties. So if you find a great property for them that is not within 10 miles of the military installations or critical infrastructures, that is not agricultural land, you really don't even need to think about this, because those are the
Yeah,
restrictions.
but you're saying there's no map to this, so we can't even really know.
There's not, but you have a list of what the infrastructures are.
Right.
And military installations, I mean, it's not that hard to find them. You can kind of gauge this. Obviously, we're not gonna be like right at the 10-mile line, probably running a little bit of a risk.
Yeah,
But if you're like 15 miles out, I would say you're
Yeah.
pretty fine here. It's okay, as long as it's, again, not agricultural land. You might wanna make sure that you're checking the zoning, because even if there is housing built there and it is zoned differently, because unfortunately, the law did not actually talk about whether it's the zoning that controls or if it's just like what you see on the land. So obviously, I want to take that into account, but it's not an absolute. This is not an absolute law. It is just restrictions. Kinda you gotta be like 5'2" to ride this ride kind of thing, unfortunately.
Yeah, like there's a camp, I think on 57th Avenue. On Honey Hill, right between Broward County and Miami-Dade County. I always drive by it
Mhm.
and I'm like, oh. I think
Yeah, there's also a
technically
training,
camp.
there's a training
5 miles,
camp on about where Miami Airport down south is, and a lot of people don't know that's there, but it's a training camp.
Right.
And it's like this big, but it actually.
Yeah, so how are you gonna search that? Like, are you gonna search every single type of facility in around this property? It's tough, right? There's no map. No?
There is no map, again, but if you have this area that you're looking. It's not that much harder to look, take a look. Yes, it's a little extra legwork, of course. But generally speaking, you just kind of gotta find one big thing to exclude that area, or you don't, kind of thing, because. Realistically, in Florida, yes, like you said, there's a lot of airports, there's a lot of military installation per se. But there's a lot of areas that you can work around that, so
Tricky point.
little extra stuff, but yes.
So if we recommend them to an attorney, what's your process? Like, let's say, hey, I recommend to an attorney, they speak to you, they call you, what do you kind of go through with them?
Pretty much those steps of
Right.
where are you citizen or not citizen or lawful permanent resident? And if they're not, where are you domiciled, what country you're from? And if you fall into one of these, well, let's see, right, is there an exclusion, not falling under one of the exceptions? Then this is your restrictions.
Okay.
For example, like I have somebody that was trying to buy within a restricted area, and I was like, essentially just residence, that's your exception. And they already had a residence, so I was like, you can't buy it there.
Yeah.
Or you sell the one you have and you buy a new property, and then you can buy it, but it's one residence only, that's it.
So I mean, if you're dealing with a cash buyer, you gotta, at some point, you may or may not ask, where you from? Right? Or maybe the title company at some point will be like, oh, right, they'll have like your questionnaire. Or if you're lending, I gotta look at.
Well, okay, so lenders, obviously, are like kind of on a different level, cause lenders
I gotta
obviously
see
is
it.
part of their application. They're not asking for the same reasons.
Right.
The thing is that as agents and like title essentially, well, even title, we're a little bit excluded too, but as agents, it can be perceived as violating federal laws, protected classes. So you don't wanna tiptoe that line. But as a title attorney, I'm in a different, first of all, as an attorney, but as a title attorney, I'm in a different seat. Why? You're already under contract, which means you've already signed a contract that has this disclosure, number one. And number two, I have to ask for, I generally don't ask buyers, because that's irrelevant for me for buyers. I'm not responsible for policing this specific law, but I will ask on the seller side. So then if I have a seller that's also buying, I already know what's going on, kind of thing. So that's why I'm saying that lenders is a little different, because it's part of an application that you are required to do for your loan. It's a very different need for that information than when agents ask for it, right? So that's why I say it's generally says CYA liability thing, you might not wanna ask that. But you can definitely make, like I said, you can definitely make that description, those 2 pages, part of like your packet, whatever info packet if you have something like that. Or like, if you just wanna email it over, like if you have a client that is very likely a foreign individual, period. And you make this a practice of, you send it to all buyers, or all buyers that you know are not, immediately know that they're not American, are US citizens. Then, you just make it a practice. They read it, if they don't read it, they don't read it. That is not your responsibility.
Send them what? I'm sorry.
The affidavit that I mentioned,
Oh,
that
okay,
they
okay,
have to
okay.
sign,
Yeah.
the last 2 pages is like a,
Do we
It's
have
like
that
a
on our,
breakdown.
on our forms through through the MLS?
I'm not sure you have it, but I can send you that affidavit,
Yeah,
or I can
please.
send you those 2 pages, because you really don't need the affidavit, you just need those 2
Okay.
pages.
Yeah, we'll have to have that.
And it's just like a little description, like who foreign principals are, what the foreign countries of concern are, and like a little bit of what's restricted. And the idea is that you send this over to them, and they'll probably only read the part of the countries, and that will be sufficient to prompt them to be like, hey, I think that I might fall under this, and that's it. Once they open the conversation with you, that's a different story. But ideally, you don't wanna filter that. Just ask them, talk to them like a regular buyer, and then we will deal with that when it gets to the part of course, the offer. With, keeping in mind, like, if they do sound to you like a foreign, or they've expressed something that indicates to you that they are a foreign principal or something, they fall into this, you need to be creative with how you find properties.
Yep.
Kind of thing. Any other questions?
I have, yeah, 2 questions.
Yes.
So let's say, I have someone that. It's a buyer and he might fall under that.
Mhm.
How long would it take to get an answer from you? Like, for example, they're like, okay, look, we wanna hire an attorney, they wanna go, just to make sure. Like, how quickly, I guess, would that take to get a response so that we're just not, because you have to place an offer.
Yeah, it's, I mean, it wouldn't be very
Like-
long, but most a day if that, but
Oh,
I'll be honest, the best thing for all of you, for if you have an offer you wanna place, or you have an offer you want to accept, there are these 2 really amazing addendums that you can add, seller's attorney, buyer's attorney, that gives you an extra like 2 or 3 days, or whatever you wanna put in there, date, you just put a date. And then you buy yourself like a window of being able to get in touch, so put in your offer, if it's a great offer, it's a great something, you wanna get it done. Don't wanna wait, especially like, let's say, an evening or a weekend, holidays, whatever the case is. Just tack that on, and it just gives buyer, seller, depending which one you use, that little window of. Let me check with an attorney, my attorney, any attorney, and I just wanna like go over this. Like, yes, I'll sign this, but I'm not like so locked in that I can't have an attorney review it, because I've seen it happen, obviously, like, we have a Monday off and it's 3 days that you can't get in touch with somebody generally, and you still wanna put it in, you obviously don't wanna lose that opportunity. I generally never had any issues with anybody accepting it when it's like not an excessive amount of days, when it's just like 2 or 3 extra days. Because in the end, for the most part, you're still in the inspection period like window too, so it's not that critical, you're not losing a lot of time. Don't obviously put 10 days, because a lot of people will not accept that.
And then another question is, will you have like a flat fee or is it kind of per case, how much it'll cost to find out, something like that?
It is per case, but essentially something like that, if it's realistically, it's not gonna take me a lot of time to analyze their situation and see. So it would be per hour, and of course, like I said, it just depends on like their situation. If it's something very basic, it's probably an hour. If it's something, when I have that initial call with that client, if it's something, because just from the initial call, I'll be able to tell them, if it's that elaborate, essentially, they have all these, like a visa this or whatever case, etc., all these extra conditions or parameters, I'm actually not gonna handle it. I'm gonna have them talk to an immigration attorney. Because at that point, I cannot make the determination of what their legal status is for this application. And that's a big thing, it's your legal status essentially is what determines, because again, if you're not a citizen, you're not a lawful permanent resident, then you're not really excluded from there if you're domiciled in another country, so.
If it's an easy, something that for a
Again,
fact, you'll handle it, if not.
however, it's very easy, I'll tell you, if this person is not a citizen and not a lawful permanent resident, and they are trying to purchase within those 10 miles or agricultural land, and it is not their one exception of the residence, it's already a no. It's that simple, it's already a no, because the visa portion of it only comes into play for this one exception. Otherwise, it's a no, if they're not a citizen or lawful permanent resident. So there's not a lot of analysis to be done. I just don't like my opinion, obviously, and you guys take it however you want, but my suggestion to you to make sure you guys are covered is just not to be the filter, not to be the polices of this law, because it's not really for you to be doing that. That's why the best thing is to just have those papers that you kind of send over, here, this is information that you should probably read. You know, FYI, this is a new thing in Florida, or it's a thing in Florida now, so. And it's out of your hands, you've sent it over.
Yeah, I'll make sure to remind you to send those to me.
Yes.
Thank you.
No problem. Okay, so, skip over to FIRPTA, because this has been in effect for a long time, and I know this is the bane of a lot of clients' existence, because, you know, who wants to lose money in a closing? So, FIRPTA is the Foreign Investment, Real Property Tax Act. And this was established just to guarantee that the United States, the IRS, can tax the sale of a real property. Now, we all get taxed on the sale of a real property, right? Period. We all do at some point, unless you have your, you know, your exemption because it's your homestead. But we all get taxed on capital gains. The difference here is that because foreigners don't necessarily have a tie to the United States, the US doesn't really have a way to guarantee they're gonna pay those taxes the next year when they do their taxes. So they created this withholding at the moment of closing to make sure when the money is transferring, it's going somewhere, it's flowing, they know where it is, they can withhold it. And so that's what it is. They created that like safeguard in that moment of closing. And it creates an assumption that all sellers are foreign until proven otherwise, essentially, which is kind of crazy, but that's the way it is. And it also created a requirement that the buyer is the withholding agent. So the buyer is the one that has these requirements. The buyer withholds 15%. The buyer is the one responsible for sending in the forms and sending the money. I put a caveat down here, of course, because obviously the closing attorney or the closing agent is really the one who's going to facilitate all of this transaction. But because we are not responsible, and we're not really the ones that are the withholding agent, either our offices or let's say the CPA or whoever it is that's handling like preparing the forms, they are all allowed to charge the seller for these services. So realistically, I will tell you, like, when I've had to do closings with FIRPTA, when they are gonna do certain types of withholding, so they ask for a certificate, and I'm gonna explain that. I don't handle those, so the CPA will charge them for those fees. When it comes to the part where we're just gonna send the straight 15%, it is a very basic form, well, not basic form, it's a standard form. Essentially, I almost never charge for it unless there is some kind of extra information, extra legwork, etc. Because really, it's just straight 15%, there's not a lot to be done. I'm not calculating anything, my calculator's doing it. I'm not like making up any information or any conditions, so you have an idea, it is allowed to be charged, it is actually on the contract, by the way. In that section 9, where it says the closing fees, in the seller portion, it is on there. It's actually one of the bullet points, so just in case your seller's asking you.
In your calculation, if there's a loss, you still need
You
to
don't
know.
calculate losses, so when you do FIRPTA, it is 15%, because it's not a tax, and we're gonna get there, it's not actually a tax, it's a withholding. So these are the exceptions to FIRPTA, so if the exception does not apply, the buyer is required, as withholding agent, to remit the funds to the IRS with the forms. If one of these apply, then of course they're not doing so. The two that I highlighted, so number 1 and number 6, are the actual only point blank, never like can go against them exceptions, because if the seller's not a foreigner, they do not fall under FIRPTA, period. Now, there are requirements to the seller proving this. I'm gonna talk about that. But that's number 1, and number 6, if it's the US government, doesn't apply, period. The end. So if these two are in existence, then the buyer doesn't need to worry, you know, nothing to think about. But 2 through 5 are not guaranteed to the seller. The seller might request them, but the buyer is not required to accept it. So, and I'm gonna go over each one of these, but just so you have an idea, the most common one is number 3, other than 1 and 6, is number 3. I've been asked this a lot, which is, you know, when it's under 300,000. That's not actually an exception, it is a reduction, but it falls under this exception list. And so I'm gonna explain in a lot more detail.
Yeah, part of that has come up a few times, that
Yes.
question, yeah.
Yes, I'm gonna talk about that. So, first of all, what's on the FAR bar? The FAR bar tells you that there is no retention if the seller can provide that certificate or affidavit, they're calling it now, under penalty of perjury, that they are not a foreign individual. That's exception number one. That's what I said, that there's a requirement on the seller to provide this. The second one is for exception 6. There is no requirement for the buyer to accept anything other than those 1 and 6. And then, like, that's why I put asterisk is for withholding certificate, and there's a reason, because a withholding certificate is not necessarily an exception, first of all, because it doesn't necessarily remove them from FIRPTA. And you actually have to have it in hand for it to apply. And I'm definitely gonna speak about this in detail a little bit more, because that's where a lot of people get a little bit lost. But the most important thing is that the reason that buyers are not required to accept any of the other ones, so 2 through 5, is because it puts the risk on them. If they incorrectly accept one of these exceptions, or if they knowingly accept it that is not applicable, they are then responsible for all of the taxes required on this sale that the seller didn't already pay, which if it's a foreign seller, we all know leaves with money, doesn't pay anything, right? They don't file taxes a lot of the times. It's not, obviously not a guarantee, but a lot of times they don't do the taxes. So I am not really gonna like go into super detail of these sections, but it's on the slides for you, because these are the key points in the FAR bar. It's already in there. There's nothing to be discussed. And the first one is the seller is going to inform the buyer in writing that the seller is a foreign person. So this one is, I think, the line that's most important in the contract to me about FIRPTA, because I have already I'm almost doing this 10 years, have dealt with sellers hiding this, purposefully hiding this. The contract requires it of the seller. There should never be a point that we are 5 days from closing and oh my God, FIRPTA applies. Oh my God, the seller is a foreigner. And oh my God, the seller does not want to pay FIRPTA, they want to back out of the contract. That's a no, that's a big no. It's so really honestly a too bad, so sad, but realistically, if you have a seller.
Is that on the seller's disclosure?
I think it might be, yes. I think it is, I'm pretty sure it is, but even if you don't use the seller's disclosure, so a little side note on the seller's disclosure. The format for the seller's disclosure is not a requirement. So if you guys want it and you're on the buyer side, make sure you put in the additional terms, right? That they're gonna use the seller's disclosure and they're gonna give it to you within a certain amount of time. Otherwise, the contract does require disclosures from the seller, but it does not name the specific format for these, so they could just send you like an email kind of thing. Not the best, obviously. The reason that the seller's disclosure is like so popular is just because it has a lot of like things in there, it has a lot of details, so it prompts the sellers to remember a lot of things, which is obviously very helpful. If you're not in the habit of using it for your seller, honestly, I would encourage you to do it, because your seller's probably not going to remember half the things that get asked on there. And the things that get asked on there are things that the contract requires them to disclose. So you're doing yourself a favor and you're making it easy to use that. But if it's not on there, but I think it is, they do need to disclose that. So without asking, you do just need to tell your seller, hey, it's a requirement to tell the buyer in writing whether you are a foreign person or not. And the exclusions, meaning you're not, is US citizen, permanent legal resident. Right? Other than those two exclusions, they do need to disclose to the buyer that they're a foreign person. Okay. Then the other thing that I highlighted is just for you guys to have like in mind, if you ever sit down and actually like read through a contract like really well, if you haven't already done that, you'll see a lot of times it says see standard whatever letter, and it has more. That's because the contract has this like beautiful little section of standards that gives you the instructions for certain things. And the standard for FIRPTA is this one. And this is what I've already mentioned, which is that it requires the buyer to withhold the 15%. 15% is the number, period. That's like the standard number unless there's something else. So like it says, unless there's an exemption. So the number 1 exemption is no withholding if they're not a foreign person. And then the number 2 is if they have received a withholding certificate. And this is something, again, like I'm gonna go over more, but received, meaning they have it in their hands. Not that they have applied, because if you see in number 3, it says if they've submitted it, the application for it, but have not received it at closing, then the buyer can decide whether, number 1, they're gonna send the money anyways, or number 2, they're gonna put it in escrow. So what I have encountered in closings with sellers occasionally that are subject to FIRPTA. Is that they wait till the last minute to do their withholding certificate, which means or the application, they're not gonna get it by closing. Cause in the last couple of years, the processing time has increased to like almost over 2 years. And then it goes up and it goes down, it fluctuates a lot, but never is it like 5 days kind of thing. Number one. Number two, what they don't understand is just because they apply, the buyer's not subject to what their application states. Their buyer can only then decide that, okay, we're gonna leave it in escrow. And then the seller is responsible for paying for the escrow services. But it's still the 15%, because again, you cannot reduce what you're putting in escrow because the IRS has not actually approved that certificate. And if they don't approve it, in fact, if they completely reject it in full, we have to go back to the 15%. So you cannot withhold less than 15%. Now, if you had the withholding certificate in hand, then you already have the approval from the IRS, and then you remit whatever it says on there. The last little piece that's important there is, it hasn't happened a lot lately, but when values were much lower, occasionally the 15% from FIRPTA would throw off the proceeds. Essentially, they would put the seller in the negative. If the seller is in the negative, they're not allowed to back out of the closing. That's not how that works. They do have to bring the money to closing to make up the difference. So these 3 things. Why is the buyer the withholding agent? So it's very important because I get a lot of questions about this, especially when you're representing a buyer and they're like, I don't know why I'm responsible if the seller is the person that's a foreigner. Number one, it's because of the money. The buyer's bringing the money, that means they control the money, and until the moment we are closed and funded, that is the buyer's money. So when I'm doing title, I cannot move a single cent of that money until we are officially closed. So up until that moment, that is still the buyer's money. We're not talking about the deposit, because obviously the deposit is subject to the terms of the contract. Talking about the rest of the money.
What do you mean? Because the buyer's bringing in all the money for the transaction?
Yes, so that's the buyer's money. Since the buyer is bringing that money and they have control of that money up until we are closed, the IRS has put that responsibility on the buyer. You have money in hand. Up until the seller leaves with that money, they get their wire, you are the ones with the money. So you are responsible for making sure that they don't get the full amount of that money, that it is minus that 15% withholding. The second part is because they are taking title to that property, and since we know that houses don't have legs, they can't, get up and leave. The IRS knows full well where they're going to find a property of value that they can essentially lien if something were to happen, right? There's actual contact with the buyer. And that's what number 3 is also. So because there's contact, because they have the interest in that property, first of all, they have a property worth money that could potentially be put in jeopardy, but also they have physical contact with the buyer somewhere. That's who they're going to put the onus on. That's who is going to be responsible for this withholding. The buyer is only going to be in jeopardy if they play around with these responsibilities, right? Only if they decide, I'm going to be a good person, or I'm gonna, negotiate with the seller and somehow we're not gonna do FIRPTA. And then the IRS figures out that there wasn't an actual exception, then the buyer is gonna be on the hook because they are going to be responsible. So, the goal obviously is no retention. So this is number 1, this is the one in there, not a foreign person. And obviously, this is a requirement for the seller to sign this. You guys don't have to have this memorized because this is part of the closing documents the seller always signs. But just so you have an idea, this is what they would have to include on that affidavit. That statement is already pre-printed, so they're really just putting their home address, their either ITIN, their EIN, their SSN, whatever applies to them. Also, important note, just because they have a social or an EIN or an ITIN does not mean they're excluded from FIRPTA. That does not mean they're not a foreign person, because you can actually get an EIN for foreign companies also. So it's important, just because they tell you, well, I have a or a lot of people will call it social anyway, it's just because I have a social does not mean I'm excluded, that's not the determining factor. Like I said, the determining factor is US citizen or permanent resident.
Yeah, I've had a client, I think it was a foreigner, he got a social like 30 years ago.
Yes, when they were giving out like
Yeah.
candy, yes,
Yeah.
I know, happened to me too. And but they were never finished their process of getting their residency, never finished any of that, so they actually were not gonna fall under the legal status that they needed. The buyer should keep a copy of that affidavit for 6 years, and the same as the knowledge that I was talking about in the foreign buyer section, it's the same thing, the buyer can rely on that certificate or the affidavit as long as the buyer or qualified substitute, which is like their agent, etc., does not have actual knowledge or has not received notice. Actual knowledge is super important because, again, like I said, it's not like a rumor, it's not like I spoke to them, they have an accent, it is actual knowledge. Okay. This one is interesting, I actually haven't seen this a lot lately, but substantial presence is a test that people can use to be taxed as US citizens. And essentially, when you're taxed as a US citizen, you kind of don't fall into this because why? You're already paying taxes, which is what the IRS wants. So then FIRPTA, they don't really need FIRPTA anymore because you're doing exactly what they want you to do. To be able to fall under this though, they have to be residing in the United States physically, 31 days of the current tax year. And then 183 days of the last 3 tax years broken down in this manner. So all the days in the first year and the current year, 1/3 of the days from the year before, and then 1/6 of the days before the year before that. So all the days in 2024, 1/3 of the days in 2023, and 1/6 of the days in 2022. Super important, and that's why I noted it there. You cannot close in January if your seller for some reason is gonna do this, because there's only 31 days. Meaning you're gonna be short because the day of closing doesn't count, so you gotta close February 1st or thereafter. This one, which is, I know this comes up a lot, and I'm sure it's come up for you guys before, so $300,000 or less,
Yeah, like if, oh, I'm selling my houses for less than this amount,
yes.
I'm exempt from this. I've
No.
had sellers say that.
Yeah, that's not how that works. So yes, $300,000 or less is one of the requirements, but you also have to meet the other ones. Number one, the buyer has to be an individual, meaning they're taking title under their individual name, not an LLC, not a corporation. The buyer and the buyer's family, immediate family, so there's a restriction on this, like kids, parents, I think cousins, and like that's pretty much it. It can't be like, super distant relatives. Will reside in the property for at least 50% of the time it's in use. And this is like a tricky one. I know a lot of people get like confused with this. So the way this works is, let's say in those first 2 12-period months, they are going to live in the property, or it's gonna be in use for 6 months. So January through June, and then June, they're gonna go to their secondary property. If they're only gonna use it for 6 months, they have to be the ones personally to reside in it half of those 6 months. Not half of the year, half of those 6 months. So they'll need to reside in it 3 months of the days, and then the other 3 months, whatever they wanna do with it, but they do have to do that. It cannot be for commercial use, it cannot be vacant, and it cannot be in the process of, or going to demolish it. And the buyer has to agree to execute an affidavit. This one's important, and this is something I'm gonna touch base on again later. The buyer's not required to sign this affidavit. The seller cannot force them to sign it. The seller cannot require it to sign it. The seller cannot put terms in the contract requiring them to sign it. Period. The end. It's that simple. The buyer has to be willing to do so, because what happens? If the buyer cannot comply with these, and later on the IRS finds out that they cannot comply, the buyer is then gonna be again responsible for those taxes. The only way that it would be an exception for the buyer is if they didn't know they were not gonna be able to comply with it. Some like something happens that they were not aware they were not gonna be able to comply, but they fully were like intending to, they were in the process, whatever the case is. That's like a very minor exception. So the buyer puts themselves at risk by signing this affidavit. So the seller cannot require it, period.
So would you say it's a added benefit if you're offering 305, 307 on a seller that is for national, and be like, hey, listen, $299, $999, we'll get a better deal, right? Assuming they meet these requirements. Cause they'll be withholding to zero, no?
You mean,
Under
if-
300,000.
we're assuming that the buyer is willing to sign the agreement and the
Or-
seller is not in any way trying to force them to do so.
I mean, we'll take it or leave it, 299, right?
You mean 299 includes the requirement of this?
Or
No, you can't do that.
why not? If the buyer
Again.
doesn't wanna,
How are you gonna require it?
what do you mean?
Your
Like, you
seller's
cannot
a- okay, so
require the
your-
seller,
your-
but it's your offering, is your offer.
No, that's literally what I just stated. You can, the seller can accept this 299, but where is it gonna be put in writing that that the buyer has to sign this affidavit?
No, assuming the buyer signs the
So it's
affidavit.
the affidavit signed at closing.
Right, but you know, isn't normally it's signing a contract that the buyer is gonna sign something at closing?
It's not enforceable.
Okay, well, it's assumed that we all meet those requirements.
If you meet those requirements and the buyer's therefore willing to sign the affidavit,
Mhm.
then yes, obviously it's great. But that is a risk. Because again, you writing it into the contract is unenforceable. Because per the terms of the contract, which means that you are writing terms that are contradictory to the standard terms of contract. The buyer is not required to accept that.
Pretty messed up. That is-
How so though?
if it's, I mean, it's courtesy business, right? It's not, we're not trying to cut through anybody, ideally. Right?
Courtesy, how? Because the buyer is getting the seller to 0%?
Assuming
But
the
the buyer's
buyer.
taking the entire risk of
Yeah,
it?
but let's just say, I'm just saying, a 310 purchase, like an offer, they're listing it for 310. You know, the seller is buying it, right?
Mhm.
So they would. Assuming they meet other requirements and assuming everything you just mentioned,
Yes,
okay?
but here's the thing, you're talking about requirements on paper. The
Right.
buyer then has to continue to meet these requirements for the next 12-month periods. And if the buyer cannot, or never really had the intention to do so, whatever the case is. And they don't meet it, and it's not like one of these, I'm telling you, it's a very narrow exception by the IRS.
Mhm.
The buyer's then on the hook for the taxes of the capital gain.
As long as they're aware of what they're listing. at
Again,
the
well,
beginning,
again,
right?
that is why it is the buyer's prerogative and only the buyer's prerogative, whether they're going to sign it or not. The seller cannot force the buyer to sign, period. And it's an additional term of the contract is unenforceable. Period.
Right.
So per these same requirements, you can apply this to a sale over 300,000. In between 300,000 and 1 million, but it would then only reduce it to 10%. So the withholding certificate, as I mentioned, it's not really an exception per se, because the withholding certificate is actually a response from the IRS to an application that the seller sends in showing their calculations and the fact that they don't actually owe, they're not gonna owe a 15% tax, they're gonna owe much less. So they send in a calculation where they'll show like the amount of sale, their like losses, any money they put into the property. And like what they think the calculation of their taxes should be, and then the IRS will then respond approving it or not, and if they approve it, it can either be reduced from 15% or reduced all the way to 0. That's why I say it's not really an exception, it's more like a reduction per se, because it's not guaranteed to go down to 0, it's somewhere in between 0 and 15. Ideally, this is not gonna work for every seller, and I'm gonna talk about that a little more.
How long does it take to get that certificate, more or less?
That's what I was mentioning before, I don't know the like timelines right now, but they vary because. It depends how many applications the IRS is getting, it depends also how backlogged they are. In 2021, there was a backlog of 2+ years.
Oh,
So
yeah,
you
so
were
they
waiting,
can't even
so
get
the
that,
money was
like,
in escrow for 2+
if I talk to a seller, they wanna put the property in the market now, yeah, they're not gonna get that. They gotta do that way ahead of
So
time.
here's the thing, and I'm gonna touch this a little bit more.
Yeah.
It's not for every seller, and honestly, right
Yeah.
now, it's probably not for any seller, period, really. Because the odds of them being able to show
Yeah,
enough losses, enough documentation of what the IRS requires in their application.
yeah.
To show that they actually are gonna owe less than 15% on those capital gains. Is now very rare, so a lot of people are not gonna even bother
Yeah.
doing it, they're just gonna let the 15% get withheld and that's it. And then they're square with the IRS.
Yeah.
Because something that, and I'm gonna mention again, is this is just a withholding. This just means the IRS is gonna hold those 15%. And if the foreign individual does file taxes and does show losses and does et cetera, they are able to get it reduced from 15 and get money back. But then that's on the foreign individual. The IRS already has the money held, essentially escrowed, unless the foreign individual does nothing and then it is the tax. If they wanna apply, this does come up and they do wanna apply. The most important part of it, if you have a seller that's even contemplating it and you're gonna eventually list this property. It is very important for them to understand this is not a last minute decision because the CPA cannot prepare this application for them in less than 24 hours. They generally can prepare for them in less than a week kind of thing because there's a lot of documentation, numbers they need to show. And that application has to be postmarked by the day of closing. Postmarked, like in the post office, they need to stamp it for you so there is proof. Because don't put it in like a mailbox and not know that it gets stamped. Because if it is not postmarked, it is automatically rejected by the IRS. Period. That's it. Your window closed. And since it takes more than a couple days for this to be prepared, they need to be starting this process with time before the closing. You know, if they started before they even get under contract, that's amazing. We all know that generally doesn't happen, but if that's even something they want to contemplate, encourage them to talk to the CPA early on, very early on. And the last exception is a transfer of $0. So we're talking about quitclaim deed or gifts. I'm gonna touch on that a little bit. So super important, like I've mentioned before, buyer does not have to accept an exception, and we're talking about other than number 1 and number 6, and then having like a withholding certificate in hand. And again, I don't really call it an exception, but so they don't have to, period. Like I mentioned, it's not always a good idea or beneficial for the seller to apply for a withholding certificate. In addition to the fact that it's very hard to show, you have to show a lot of losses to be able to bring yourself down from that 15%. The other side of that coin is if this foreign seller has multiple properties or other assets, et cetera, et cetera, et cetera, because this is not just, we're talking about one, we have to show losses, so they are gonna be putting themselves on the IRS, on their radar. Do they actually want to do that? Is that worth more to them than the 15%? Because, again, this is not, they're not getting taxed because they're a foreigner. It is happening at the moment of closing because they're a foreigner, but they are getting taxed because there is a sale of an asset and capital gains has to be, you have to pay taxes on capital gains, period, on any sale of any assets, not just real estate. So they're not getting any extra like burden on them, it's when it's happening is the difference. But again, do they want to be put on the IRS's radar? Or do they want to walk away from 15% and the IRS doesn't know what they actually own? That's the reality of it for some owners, for some company, for individuals that have these kind of companies that have multiple properties. And something that I brought up already multiple times, it's obviously very important to talk to a tax attorney, a CPA, or somebody with FIRPTA experience. And this goes for not just the seller, but the buyer too, because if one of these exceptions is being brought up, and it is a very well documented exception, let's say for the substantial presence test, et cetera, and they really want to contemplate it, the best thing they can do is to talk to a tax attorney to understand their risks, their liabilities, et cetera. So, if the seller is trying to avoid FIRPTA, there's some things that we want to be aware of, and we want to stay away from just in case. So they're proposing transferring it via quitclaim deed because the quitclaim deed has no value attached to it, so there's zero transfer, zero FIRPTA. It's very important to understand 2 things. Number 1, it would be considered a gift, and gifts are subject to gift tax. So the person receiving it gotta pay a tax, right? So if you're doing this as like legitimate gift to somebody, okay, but if you're doing it to avoid FIRPTA, number 1, that, but also those can be considered tax evasion.
What is the tax on that?
On gift tax, I don't actually know a percentage. So it could be considered tax evasion. The second part to this is if you're already under contract, quitclaim deeds violate the terms of the contract. The contract requires that a transfer be made via a warranty deed or a personal representative's deed. So you cannot do this. The end. So, and like I mentioned, it's a withholding, it is not a tax. It is a standard withholding against what could possibly be the tax, which could be more, or it could be less. And that's why you have like opportunity. Again, like I said, the seller could the next year file their taxes and possibly get some of that money reimbursed. But is it worth it to them for them to do so or not? LLCs, do this as fast as I can, so we can wrap things up, but LLCs are something that, for you guys just to have like knowledge about this, it's really not, you're not gonna do this kind of like mental gymnastics. But LLCs are like the second trickiest thing to determine if FIRPTA applies or not, because LLCs are like something they're like a very special type of business, the way that they're taxed, the way that they're set up. They're not a corporation, they're not really a partnership, but for tax purposes, they could be a corporation, a partnership, or what we call a disregarded entity. They could be one of three things, which is bizarre because obviously that's not what they're called. Now, the way it's seen is if there's a single manager or single member, it is default to consider it a disregarded entity, meaning in the moment of calculating taxes, the LLC's taxes are calculated, and then whatever income there is after all that, those calculations is then apportioned to the actual owner, the single member or single manager's income, and then their taxes are done. If that's the case, then FIRPTA does apply if the owner is a foreign individual, and you do it based on the foreign individual's tax ID and all of that stuff. If there is, the exception to that is if they are electing to be taxed as a corporation, like I said, this is always a risk for the buyer to accept something like this. If there is more than one manager, generally speaking, it's fine, you can go ahead with no FIRPTA because they are taxed, almost always they're taxed as a partnership. I have never seen a multiple member LLC that chooses to be taxed as a corporation. I have seen a single member one taxed as a corporation, being able to show it. But I have never seen really a multiple member. They usually do partnership taxes, so they have like Form K, I think it is. And so they're taxed like that, which means that the LLC is actually doing taxes. You don't need to worry. The LLC is paying those taxes, meaning the IRS is gonna get their money when the taxes get handled, so FIRPTA doesn't apply anymore. Married couples that own LLCs are tricky because they could choose to be taxed as partnerships and doing their Form K, or they could be doing their taxes together and it becomes a disregarded entity, and so then we have to go back to them as individuals, whether they're foreigners or not. So it gets a little, a little bit of mental gymnastics, gotta do some math there. The next one that comes up a lot is when there's multiple sellers. I put two, but like obviously multiple, and one or more of them are foreign individuals. So we break it up. Let's say, for example, married couples, you default to it's a 50-50. If there's one person that's a foreigner, you take 50% of the sales price, and that's what we use to calculate it. For other ones, partnerships, multiples, etc., you do it based on the amount of number. The presumptive way to divide it is the amount of owners that exist. So 3, we're gonna do thirds, 4, 25%, and then we use that. Unless there is an agreement, prior agreement. And we're not talking about an agreement that got signed last minute for FIRPTA purposes. Please do not do that. The agreement needs to predate the contract for it to actually be like, enforceable or like use it, because if there's like a multiple owner situation and there's an agreement the day before closing, it's very much so going to be considered tax evasion, because all of a sudden the foreign owner has 0% interest. We all know that that's not the case, so let's not do that. So we just do presumptive. So for example, like I said, 500,000 sale price, it's husband and wife. The husband's a foreigner, so we're gonna take 250 and we're gonna do 15% on that 250. Very easy. So if you do have a couple or partners that, and we're talking about partners that are not under an LLC, we're talking about like individuals, like 3 or 4 individuals that own it. So obviously if it is a company, we're doing it as on the company first, and then if they don't qualify, then we'll go down. But we're talking about, when I say partnerships, I mean like people getting together and buying a property together. And so then we'll look at those. Okay. Last couple things. The The withheld funds have to be sent within 20 days, or if the seller has applied for the withholding certificate. And the buyer is willing to leave those funds in escrow with like the title company or the title attorney or an escrow specific company. Then it would be within 20 days of receiving the withholding certificate. Okay, so it is a very short window. If not, the buyer can be in trouble. The second part is if your seller is a trustee or a personal representative of an estate, they can still be excluded from FIRPTA if they're able to sign that affidavit that the trust or the estate is not foreign, but they'll be signing it at like an individual basis. So not just as a trustee, but also an individual basis, okay? This one's comes up a lot,
That's an exchange.
so I'm gonna take 2 minutes extra for that. 1031 exchanges do not exclude and they're not an exception from FIRPTA. But, and this is the big but, do not discourage your sellers from doing it. In the moment of closing, if they're subject to FIRPTA and there's no other exception, we'll still withhold the 15%. It gets sent to the IRS, right? They're still gonna do their 1031. That just means they are short 15% from the proceeds when they do their 1031. They're still gonna put the rest of the money. They're gonna do their 1031 the way that they're gonna do it no matter what. When they go to file taxes, when they go to do all their paperwork and etc., they may be able to recuperate their 15% in full because 1031 does essentially remove your capital gains taxes. It doesn't eliminate them, it rolls them forward, but they have complied. The thing is that what people like, I feel like sometimes don't understand, but like the important thing to remember is 1031 does not stop it in that moment, because 1031, you need to complete your 1031 for it to qualify, which means if they're selling that property, they haven't actually, if they're doing a traditional 1031, they haven't finished it, and so they don't qualify for the exception or the rolling of the capital gains tax. But they are doing what they need to do once they finish it, and that means they can recuperate it. So in that moment of closing, FIRPTA will still apply because that's when it applies. That is the moment of FIRPTA, but 1031 won't be done. So again, it cannot be an exception for them. But it is still, if that is something they're thinking and it's worthwhile for them, not for FIRPTA only purposes, but it's something they are planning on doing anyways, they should still do it. One doesn't necessarily have to do with the other, but it's still a very good idea. The last thing that it's like the last thing that I've mentioned multiple times, it's just very important to keep in mind, especially when you are representing sellers, is that the buyer is going to run the risk. And like I mentioned, if they do not comply the way they're supposed to comply, they are going to be liable for the tax due on the capital gain and whatever has not been paid by the seller. And generally speaking, the seller has not paid anything at that point. So it's very important to keep that in mind. And like I mentioned when we were discussing it earlier, additional terms added to the contract to force a buyer to honor an exception or sign one of these affidavits, they're not enforceable because the terms or the requirements of FIRPTA are already on the contract. Any additional terms that you write in that contradict that are invalid, essentially. And what's very important to keep in mind is you guys are not attorneys.
No.
Do not edit the contract. Do not edit any of the standard terms of the contract. What additional terms function as is added. If you put something like that on there, it's not adding, it's actually editing, it's changing something. So you're not supposed to do that. It's not gonna be valid. You're removing a right of the buyer on the contract, which you cannot do, right? So it is important to keep this in mind. You should never be editing any of the standard terms on the contract. Additional terms should just be an addition, an extra condition, an extra something.
But I've had attorneys cross out a bunch of stuff in my contracts before.
From the regular FAR terms,
Yeah, they always wanna cross out.
Cross out a ton of stuff.
A ton of
I
stuff.
have never accepted something like that. I tell you what, I know that they cross out damages, and damages are,
Maybe.
you cannot be crossing damages out. That
Yeah,
is
they-
a
no,
huge deal.
It had to do something with the seller's deposit or the buyer's deposit or something like that.
Yeah, no, that's a no, but
Yeah.
But again, it's a little bit different when an attorney is doing it than when you guys are doing it
Right.
as just a CYA. I definitely would not. here's the thing. The reason I tell you guys how to do it is because you're not an attorneys, right? So you don't know which one of these terms are statutorily based and not, or not. So you don't know if removing a term will violate a law. Obviously, we're taking under the presumption that the attorney that's doing this does understand which one is it.
Right.
That's why the FAR bar has been created, so you guys don't have to guess this. In the end of the line, a seller and a buyer can agree to anything. I've seen contracts between buyers and sellers directly that are not even remotely close to the FAR bar, and they're horrible. Realistically, don't ever do that, just don't. I don't ever like advise that because half the time they're missing so many details,
No,
right?
I agree.
FAR bar was
Whatever you
created
wanna
to
do,
help you guys.
just put additional terms or.
Right. But the additional terms, again, should not be contradictory to what's already on there, because you are creating. Not only are you creating that contradiction, but you're creating essentially a future legal issue, because they're contradicts, so which one controls? It's just not, it's not a good idea to do so. Especially not without the advice of an attorney to be able to change that. Okay, so. I don't know if there was any, I know I ran a little late, if there's
No,
any
you're good.
extra questions.
Anybody on the chat have any questions, guys? That was it. No, I appreciate for those, I mean, for everybody who has never done a FIRPTA deal before, to be honest, I know there's a lot of stuff, and the good thing is to just be knowledgeable and having conversations with your clients. But a lot of the stuff, like I've done FIRPTA sales before, and I don't 90% of the stuff she talked about, I have no idea. It just kind of goes on behind the scenes. We get somebody that has experience settling and closing files that are involved with FIRPTA, and I let them handle that. You know, we don't try to be experts, but the reality is clients do ask us a lot of stuff. I've gotten a lot of things with oh, well, I'm selling my property for less than this price, I'm exempt, or I have this exemption, or I have this, or I have that. And then sometimes then we have to kind of get involved a little bit, but leave it to either an attorney that's handling the closing and just let them handle all that stuff, because yeah, I don't like to get involved that. And if we're representing the buyer, or my thing is always withhold, like, yeah, just, you know, just always withhold, because you don't want the buyer to have any liability or anything like that. I don't think we have any questions on the chat, so nobody else posted anything, but anybody, you guys have questions?
Do you mind elaborating a little bit more on the 1031?
Mhm.
Just in fact, because like I have a lot of questions when it comes to my sellers. Like I sold a property and they're like, oh, what am I supposed to do with the 1031? And I personally don't know. But that's just me.
So, definitely we should set up a 1031 only, like,
Mhm.
but the gist of 1031, like, first of all, the most important thing is. You have to have the process started before you close, because the seller cannot touch the money. So there is an intermediary company that they have to hire that handles all the paperwork and holds the money, so. The seller will close that money,
Is the capital gain,
no, all the money that comes out of it, the proceeds of the.
that's it.
Because capital gain is not on the proceeds only, it's based on a calculation, right? So, but the proceeds only, so let's say they sell for 300,000 after everything that they have to pay off, they get 100. Those 100 have to go to that intermediary, they don't come to the seller's account, they don't come to the seller's title company. Then they have that amount of time, depending on how they're doing, but generally speaking, they have their 60 days to. 60 days to identify, and then there are 180 days to close, so that money would go directly to the title attorney or title company and whatever, whoever's handling it, to close, meaning that money never goes into the hands of the seller, that's the most important thing. So they will not be able to do a 1031 if they've already closed. Period, they've already locked out. It's very important if a seller is even contemplating a 1031 to ask these questions, to talk to a 1031 company or talk to an attorney that knows about 1031 prior to. I would say even like, I don't know, listing, but really, I know a lot of people leave things for last minute, so at least the moment they're under contract. At least get the information, if they end up not wanting to do it, that's great. But what I have advised clients before is, if you're considering it. And it looks like it's a good deal for you. The worst that could possibly happen is that you hire this 1031 company. And the closing from your sale happens, the money goes to them. And then you choose not to identify. You, meaning you will not be able to get the money back until day 61, right? Okay, 2 months. What is 2 months? So your loss will be, at that point, your loss will be 2 months and 1 day. And the fees that they charged you for that portion of it, the 1031 company is what I mean. Or your alternative is you are now in a 1031 guaranteed and you have those 60 days to determine whether you actually want to move forward or not.
And there's no penalty other than the fee.
There's no penalty because at day 61, you tell them by day 60, you tell them you're not gonna identify and you don't wanna go forward and now, if you do identify though. And then you still don't wanna go forward, you cannot purchase one of the identified properties. At that point, then you have to wait for day 181 to get the money back. Okay, right? So, but there's still no penalty other than the fees. It's just a waiting game at that point, but there's still no penalty. Again, in my view at least, waiting 60 days or having those extra 60 days and paying a fee for this company to hold the money. But still buying yourself that extra time after closing to determine whether you want to move forward or not is still better than at the moment of closing, oh my god, I wanted to do 1031 and too late. Now, I do know some brilliant companies that like within like 2-3 days before the closing can make it happen. Like the paperwork and everything, but honestly, that is not where you want to be, because that is insane. Yes, it is, gets a little crazy. You have to make sure you sign everything on time, like everything gets the buyer has to sign things, you have to sign things. Per the terms of the contract, but when we're talking about strictly FAR bar as is. 1031s, the seller and buyer. The parties of the contract cannot cause or cannot say, no, they're not gonna participate, no, they're not gonna sign in the other person's, whatever documents the other person's 1031 company requires. But it also says there are no extensions, delays, etc. of the closing date to consider 1031s. So just because your client is doing a 1031 or wants to do it and says they're gonna do it, signs an agreement, and we're 24 hours from closing, they can't get it done in 24 hours. They're stuck. But that's why I was saying 1031s, they're still a good idea for sellers or foreign individuals, because since they're technically not done with the transaction of the 1031 process until they purchase the replacement property, because that's what it is, it's a replacement property. They are not qualified for that. It's really a deferral of capital gains tax. They're not qualified for that deferral until they do that. But FIRPTA applies at the day of closing of their sale. So that's why 1031 does not remove FIRPTA, but it could return it. Obviously, a little bit of more legwork, but I mean, depending on what the size of the sale is, 15% is 15%, right?
And then identifying the properties, how many properties can you identify?
I believe it's 3 in a standard one. Now, there are other types of 1031s, right? And this is a lot more detailed. But there are other types that have requirements, but you have to, for the standard one, which is like sale, purchase type of thing. I believe it's 3, and they have to at least, this is like another requirement for 1031. 1031 does not mean you're gonna take, let's say from this example that we were using, the 100,000 proceeds and reinvesting them. No. The sale was for 300, so your purchase has to be for 300. And again, like I do a lot of, I talk a lot about 1031s, and I can definitely do a chat. But there is like, it's a lot more details I would have to show you as far as like when you do like a standard one, those 3 you can get, you don't have to get one. That's not 300,000, you can get more than one, but then it gets a little more complicated, because if you identify a certain amount and then you're gonna get multiple of them, then it has to be like an 80, it's a lot more complicated than that. So the way that I explain it generally is you can identify 3, you could buy like 1 or 2 that add up, or 1 only, but like this is the most basic, most straightforward is sell by 300 to 300.
Yeah, I get a lot of questions with the like kind properties too. People always wanna like sell one type of property and buy another type of property with 1031 exchange with like a multifamily, and I wanna buy a warehouse. Isn't it supposed to be like kind or similar?
it is like kind. I've never had an issue with selling multifamily to a warehouse, but it does have to be an investment property. It cannot be a vacant, if I'm not wrong, it cannot be vacant land. Obviously cannot be residential. So I would have to look more specifically.
As long as it's an
but
investment property.
yes,
Yeah,
so I'm not sure that a warehouse would be excluded.
Has to be a structure, can't be land.
No, it is real property, it just cannot be vacant. So, in the end, it does have land, it just can't be vacant land.
yeah, so it doesn't necessarily have to be similar in type of property, like,
Not from what I've seen,
yeah,
but it's not super common either for people to sell a residential and then buy a warehouse.
yeah.
That's more of the rare, the same way that it's very rare that people actually do, like, when they do a 1031, they'll be buying multiple properties, usually they just sell one by one.
Yeah.
Again, there's also like a reverse one, but most people don't do that, it's, again, very rare, and the seller has to front the money. So it's generally not something that they do. So,
Alright, well, I don't think unless you guys have any more questions, I appreciate your time. Thank you so much for coming through. And then we'll talk, hopefully, maybe we can set up that 1031 exchange talk too. I think that'll be really, really good.
absolutely.
So, alright, guys, I'm getting off the Zoom because I gotta run. If nobody has any questions, peace out. We'll be in touch, okay?